All right, Dave, we're ready to get going.
Great. Well, welcome everybody. My name's Dave Zapponi, and I'm the Executive Director of ECHO, otherwise known as the Educational Council of Homeowners. We're based in San Jose, California, with satellite offices in Tracy and Laguna Hills, California. Thank you for participating in the ECHO live stream event on the road to new rental restrictions, featuring Laurie Poole and Alex Sohal. ECHO is a statewide nonprofit association created to support HOA board members and engaged homeowners. Our mission is to foster better quality of life in community associations through education, advocacy, and connection. ECHO is 47 years old, which makes it the oldest association representing collective interests of HOAs in the state of California. It prides itself on providing quality educational programs to build stronger communities. Before we move on with the program, please note this webinar is scheduled for an hour and a half. Feel free to leave the meeting at any time. Attendees will be muted during the presentation to help with sound quality and to assist the speakers in developing concepts. Please note that we use the chat feature, that is the chat feature for technical issues, and the Q&A feature for content-related questions. You may ask questions throughout the presentation using the Q&A feature. We will be vetting and answering questions as they come in. We have over 380 registered attendees for this webinar, and we may not and probably won't be able to answer all of the questions. Please be courteous and respectful of the meeting participants at all times. We reserve the right to mute or remove participants at any time and for any reason. This program is copyrighted by ECHO and will be recorded. We do not give permission to others to record the meeting without prior authorization. A copy of the recording along with presentation slides will be emailed to registered participants within 7 to 10 days. ECHO is a nonprofit corporation which has and strictly follows an antitrust policy. It is available for review on our website at www.echo-ca.org. Finally, none of what is being said during the meeting shall be construed as specific legal advice from either the speakers or ECHO. If you wish specific advice, we encourage you to ask your attorney. Our sponsors for today are, our program sponsor today is Access Construction and Grayson Community Management. The Q&A session is sponsored by Enviros Views, the law firm of Hughes Gill Cochran Tinetti, and Levy Erlinger and Company LLP CPAs. Today's dynamic sponsor is the GB Group. At this time, we will hear a few words from our program sponsors. Representing Access Construction is Dawn Alonso. Is Dawn available?
No, she's not available, so I'll go ahead and just say a few words. I'll just read from their slide. Access is unique in the industry. They're general contractors with in-house design capabilities and construction divisions, including reconstruction, maintenance, painting, electrical, and restoration. They specialize in working with homeowners, associations, apartments, and other occupied structures, and are experts in waterproofing repairs to stucco, siding decks, stairways, and balconies. Feel free to reach out to Dawn. She's provided her phone number here, and we thank Access Construction so very much.
Great. Thank you very much for that, Hannah. We'll also hear a few words about Grayson Community Management from Ray Uvishevich, the president of Eagle Ridge Homeowners Association. Ray?
Thank you, Dave. Eagle Ridge, we are a planned unit development in Gilroy, California. We have approximately 1,000 homes and 600 acres of open space. It is unique and one of the largest in the SF Bay Area. Grayson handled our transition in a 2 to 3 week time frame, which is very unique as well. They have customized their services for our community needs and our practices. They have a very attractive use of technology for the ease of our homeowners, while still having a good and responsive email and telephone presence, all to complement their on-site activities. So we are very, very thankful that they're here.
Great. Thank you, Ray. We appreciate
Thank
that.
you.
And we appreciate the introduction to Access Construction. At this time, I will introduce our speakers for today's presentation, The Road to New Rental Restrictions. For over 27 years, Laurie Poole has been a California Community Association attorney. She is a partner with Stirling PLC, managing the San Diego, Temecula, Coachella Valley regional offices. Laurie has extensive experience representing common interest developments, including master planned communities, large condominium projects, and senior communities. Most of her practice involves interpreting and amending governing documents, advising boards on compliance matters, addressing governance and insurance issues, and enforcing governing documents. Alex Sohal is an attorney in Northern California with Stirling PLC. Alex Sohal serves as corporate counsel to common interest developments throughout the state of California. Alex has developed experience working with stock cooperatives, large condominium projects, mixed use, and high-rise developments. He counsels board members of directors on compliance matters, handles contract review, amends and restates governing documents, and provides legal opinions of general liability issues involving maintenance and insurance matters. We'll start with them. Laurie?
Thanks, David, and thanks for having us.
You're welcome.
So welcome, everybody. I know that what is on everybody's mind, there's maybe another matter that's on everybody's mind today, but certainly AB 3182, the new bill that was passed by the legislature and signed by the governor, that will go into effect on January 1st, 2021. We certainly, as a law firm, have received a lot of questions about AB 3182 and what associations need to do. So we're here to break it down for you, to show you the road to what the new rental restrictions are. So Alex, why don't you lead us off?
Sure. Thank you, Laurie, and thanks, Dave and Hannah, for setting this all up. Really appreciate all the efforts you all put into this. And thank you, everybody, for joining us here today. Like Laurie said, I'm sure there's other things on your mind, but hopefully we can serve as a good distraction for the next hour or so. To start off, like Laurie said, we want to talk about the road to these new rental restrictions, and we'll start from the very beginning. So a lot of what we wanted to do is kind of talk about what the purpose of this bill was and why the legislature brought it up. I know certainly throughout the legal industry and from the homeowners that we've heard from, there are certainly mixed feelings with respect to the bill, but I think at least to start, let's talk about some of the basic facts with the bill. So it was introduced by Assemblymember Phil Ting out of San Francisco, and its main and primary goal was to combat California's housing and homelessness crisis. Obviously, that combined with COVID this year, those were the two big goals for the legislature, and this was certainly one of the big bills that they introduced to try to help out and cure this issue that they see. One thing I found that was interesting, so there were some facts that were presented by Assemblymember Ting in introducing this bill, and I want to go over a few of those with you all if you're not aware. So there are, in fact, over 52,000 common interest developments in California. And as you all may see, new developments, majority, if not nearly all of them are in fact in either an association or some form of a CID. So you're seeing it more and more that it's kind of difficult if you are trying to live in a property in San Francisco or in the California that you're going to avoid a homeowners association. So these associations range from anywhere from 3 units all the way up to 27,000 units. I know a number of the associations that I work with are within that range of about 100 units up to 1,000, 2,000, maybe 3,000. I'm not sure where that 27,000 unit association is, but I can only imagine that must be a lot of fun to deal with. The current facts are that about 1/3 of Californians currently live in CIDs, and according to the author of this bill, there are millions of of properties that are available that cannot be rented due to laws that have been put into place or rules that have been put into place by associations that prohibit rentals. So what we wanted to do here is the legislator wanted to ensure that the prior bill, AB 670, which you all may be familiar with respect to accessory dwelling units, that they could be constructed, because the idea was that people should be able to have ADUs and junior accessory dwelling units on their properties, but if they're unable to rent them, then they won't get constructed. So the idea with this bill is to ensure that these structures, these dwellings, can be constructed, and additionally, obviously, to prohibit CIDs from adopting rules that prohibit these rentals. There's a new push from what they're calling themselves are YIMBYs. We've probably heard the term NIMBYs before, the not in my backyard. Now the new push is for YIMBYs, which are the yes in my backyard. So there's all those kind of factors in support. The California Legislative Action Committee was opposed to AB 3182 for a number of reasons. One was financing and the impact that the lack of rental controls could have on FHA financing, VA financing, reverse mortgages. Additionally, there was concerns that this bill would increase investment buying. So there were a number of factors on both sides that people were concerned with, but ultimately the bill was signed on September 28th of 2020, and now we have to deal with the repercussions of it. So it is effective on January 1st, 2021, although there are some different parts of the bill that come into effect at a later stage, which we will discuss. And it does amend two sections primarily. One is Civil Code Section 4740. The other section that is amended is from Government Code Section 65852.2. And then the big part of this bill is that it adds Civil Code Section 4741. And what we're going to do now, Hannah, if we'll go ahead and jump to the next slide, we can talk about what Section 4741 is all about, because this is going to be the meat of the bill, and this is where we're probably going to be spending a majority of our time during this presentation. So it's summarized quite well on this slide, but I'm going to go ahead and read you a little bit more from the specific language itself. And it essentially states that an owner of a separate interest in a CID shall not be subject to a provision in a governing document or an amendment to the governing documents that prohibits, has the effect of prohibiting, or unreasonably restricts the rental or leasing of any separate interest, ADU, or JADU. So you see they have covered all three of those. They are considering ADUs and JADUs in this. So there is, the legislature tried to ensure that those ADUs and JADUs are going to be incorporated into this bill. And ultimately, the general rule here, as you see, is that if there is any provision in your existing governing documents, in your rules, that either prohibits, has the effect of prohibiting, or unreasonably restricts the rental of a separate interest or an ADU or JDU, then that is no longer enforceable. There are two exceptions, essentially, that the bill has introduced in Section B and C of 4741, which is that an association can adopt a 25% rental cap at the minimum. They can allow for higher rental caps, so you can have a 30% cap, a 50% cap, or no cap at all, basically allowing all of the units to be rented. But if you have a rental cap under that 25%, that's when you'll likely have to have a discussion with your council and try to figure out what you'll need to do to fix it, and we'll certainly address part of that here. The other exception is that the bill does allow for a prohibition on short-term rentals. I know that's something that myself as an attorney and counsel to associations, I am certainly concerned with, and I'm sure a number of you have experienced issues with short-term renters, weekend renters, the Airbnbs and the VRBOs and those types of renters. And fortunately, the bill does have a built-in exception that does allow for associations to prohibit short-term rentals of 30 days or less. So if you have a 6-month minimum term or a 1-year minimum term, then it's likely that that is unenforceable, although there is some question on that. But if you have basically the minimum is that you have to have at least a 30-day rental term. Anything shorter than that is something that the association can look to prohibit and likely will be successful in, but we'll certainly talk about that a little bit more. The two other sections that I did want to discuss very briefly, they're not mentioned here on this slide, but it's section D of 4741, which essentially states that an ADU or a junior accessory dwelling unit shall not be construed as a separate interest. I just want to highlight that for the time being. It is something that we're going to discuss a little bit later, but what this part of the bill is essentially looking to do is exclude ADUs and JDUs from that rental cap. So, and the other section is section E of 4741, which states that a separate interest shall not be counted as occupied by a renter. In other words, it won't apply towards that rental cap if the property itself is also occupied by the owner. So for example, if you have an ADU, which is being rented in your backyard, or a junior ADU that's in your garage conversion, if that is currently being rented, but the owner is residing on the property, then this section does basically exempt your unit from counting towards the rental cap. So we'll touch on those a little bit later, but I think this 4741 A, B, and C here on this slide are good things to keep in mind, because we're going to be discussing them quite a bit as we go forward. And I think the next couple of slides, Laurie is going to go over those details and what it means to prohibit or effectively prohibit leasing.
Yeah, and before we get to that, Alex, there were a couple of questions. I wasn't sure when we were going to touch on this, but I think this might be a good time to touch on a couple of the questions that were asked about new AB 3182 and the applicability. Specifically, a couple of questions were, are they applicable to stock cooperatives that are common interest developments? And also, are they applicable to mobile home parks? I'll take the mobile home park one. If it's a mobile home park that is subject to the Davis-Stirling Act, that it is a common interest development where the owners own their lots, or perhaps it's a condominium, then yes, for AB 3182 is going to apply to you. If you are a mobile home park that is still under the mobile home park laws, then no. This is under the Davis-Stirling Act. So if you're a mobile home park that is a common interest development, then yes, AB 3182 is going to apply to you. And all these, what we're going to talk about is applicable. Alex, what about the stock co-ops?
Yeah, stock co-ops. I saw there's some questions on that, and that's definitely something that's been on my mind. I work with a number of cooperatives, and they've actually reached out over the last few days. So I'm not sure if they're a part of this conversation, but if they are, they'll be getting some free I won't call it legal advice, but at least some free language from an attorney. And essentially the way that we're looking at it currently is that the stock cooperatives will be subject to AB 3182. And it's going to be looked at under the owners that are leasing from the cooperative. They're subleasing to other third parties, essentially, are what are going to be subject to the restrictions of AB 3182. So the stock cooperatives that I work with are either townhouses or they're in high rises. So the idea of an ADU or a JDU has not come into play. So it's a little unclear how that will impact a stock cooperative, but at least for those that are looking to establish some rental controls, unfortunately this will apply. So the 30-day and that 25% term, those provisions will apply, and you'll be able to adopt those, but nothing more stringent.
Yeah, I mean, the statute does specifically use the word separate interest, and a stock co-op is a form of a common interest development, and the exclusive right to occupy a portion of the property where the stock co-op owns is the separate interest. So our best reading of the statute is that it does apply to stock co-ops. It doesn't perfectly fit in there because it does refer to leasing and not subleasing. These are a lot of the questions that AB 3182 has raised, and I will tell you that this law has raised more questions, I feel, than it answers. So this is our best guess. And also, you need to keep in mind that, you know, we are providing general information to you all today. Do not take what we are saying as definitive legal opinions. All of you as board members, we are encouraging you to consult with your legal counsel and follow the advice and recommendations of your legal counsel. So we're putting a presentation on today of what the statute says and what, you know, what we've discussed and the questions that we've had come up since the bill was passed. Okay, Anna, let's go on. Let's break down what is prohibiting leasing. So as Alex indicated, the new 4741 says that that governing documents cannot prohibit leasing or cannot have the effect of prohibiting leasing. So what does that mean? You know, how does that translate into what we're doing day to day? What is a prohibition on leasing? Well, in my opinion, a prohibition on leasing is really that. It's going to be a provision that says you can't lease your home at all. Now, I've been doing this for a long time. I've seen a lot of sets of CC&Rs. I can tell you I've never seen a set of CC&Rs that outright says owners have no ability to lease. So I'm not aware of outright prohibitions on leasing per se. I haven't seen any of those, but maybe they're out there. I think more commonly what we see are provisions that have the effect of prohibiting leasing. An example of this, and again, different attorneys may have a different take on this. It's not specifically spelled out in the law. The new law doesn't say these are clauses that effectively prohibit leasing. It's up to us to interpret that. So again, rely on your legal counsel, but one of the ones that we do think is a clause that would have the effect of prohibiting leasing is requiring people to own or occupy their property for a certain period of time after they've acquired it before they can lease. It has the effect of prohibiting leasing because for that period of time, and commonly it's maybe 1 year or even 2 years that you have to own or occupy your home before you can lease it, you're effectively prohibiting them from leasing it during that 1 or 2 year period of time. So that's something to certainly take a look at. If you have that currently in your governing documents, that's going to be something you're going to need to look at and discuss with legal counsel as to whether that's going to violate the new law. Now, again, as Alex indicated, the 4741 has a built-in exception to a provision that effectively prohibits leasing, which is a rental cap. To explain what a rental cap is, it's saying if you have a rental cap, you are saying that no more than 25% or whatever percentage you have of the separate interest can be leased at the same time. So if you have I'm going to use easy math here because I went to law school and I don't do math. If you have a 100-unit place and you have a 25% rental cap, that means that no more than 25% of the homes can be rented at the same time. So the new law does allow associations to have no less than a 25% rental cap. It specifically states that there's nothing in the new law that prohibits an association from having a larger rental cap, for instance, 30% or 40%. But if your association has a 20% rental cap or anything under 25%, then that is going to need to be looked at as not being allowed under the new law. And how does that effectively prohibit leasing? Well, 75% of the homes aren't allowed to lease when you have 25% of a rental cap, but that is an exception. Are there other rental prohibitions or other things that provisions that have the effect of prohibiting leasing? Not very common in California, but I have seen them in other, state nationwide. provisions that say owners can only lease a certain number of times per year. For instance, maybe you're only able to enter into a lease 3 times a year, and that's it. So that could be a provision that has the effect of prohibiting leasing, because if you want to lease more than 3 times a year, then that probably does prohibit leasing. How about having the association having to consent to their rent, to the tenants, to the renters? There are other reasons why having an association have to consent to the renters is probably not a good idea. You certainly could lead to claims of discrimination for failing to give consent to certain potential renters, but that also could potentially, arguably, be a prohibition on leasing or effectively prohibit leasing if you're allowed to veto certain owners or certain prospective tenants. So that's something to again, consult with legal counsel on. Alex mentioned the 25% rental cap. I want to also mention that it does tie into Civil Code Section 4740, which came out back in 2012, as far as what we're going to call legacy. It's a legacy clause, commonly referred to as grandfathering, but grandfathering may not be a politically correct term, so we're going to use the term legacy clause. That this 25% rental cap for associations that maybe don't have it and want to put it in place, you do need to look at 4740, because that is going to, in effect, legacy in the owners who owned before you implemented that 25% rental cap. So they will be allowed to continue to rent regardless of the rental cap, but anyone purchasing after an association implements a 25% rental cap will be subject to the 25% rental cap. So that pretty much covers, those are some of the ideas of clauses that you want to look for as far as whether they could violate the new law as prohibiting or effectively prohibiting leasing. So let's talk about unreasonable restrictions on renting, because that's the other portion of 4741, as Alex went over, is that the law is saying you cannot have unreasonable restrictions on renting. So what does that mean? Again, the law has built in an exception. It allows the association to prohibit short-term or transient rentals, those that are 30 days or less. So that's not going to be deemed an unreasonable restriction if the association says we do not allow short-term or transient rentals of 30 days or less. Now, a lot of questions that we're getting is, what about longer minimum lease terms? For instance, an association may have that the lease has to be for a period of 6 months at a minimum, or 12 months at a minimum. Are those out the door now under 3182? And the answer is, well, we don't really know, but probably not. I mean, they may or may not be. It's going to really depend on, why does an association need a longer minimum lease term? And understanding that 30 days, a 30-day term is specifically set forth in the law as being allowable. What longer minimum lease terms are certainly going to be looked at more closely. They're going to be analyzed as to whether they're an unreasonable restriction. And under the Nardset case that came out in 1994, remember that in the test of reasonableness is whether or not the provision is arbitrary. So is there a reason to have a longer minimum term that is justifiable? That might help prove that it's reasonable. An unreasonable restriction is one that imposes burdens on the property that substantially outweigh its benefits. So if it's more of a burden to have a longer minimum lease term than the benefit of having a longer minimum lease term, that may be deemed unreasonable. Or if it violates a fundamental public policy. And this statute has a fundamental public policy of not allowing unreasonable or not allowing or prohibiting unreasonable restrictions on leasing. There we go. So let me give you an example of a real life example of an association that might be able to have a longer minimum lease term. I have a client that is about a 10-story tower condominium building, and they have one elevator. And I restated their CCNRs a number of years ago, and we put in a 12-month minimum because their position was, if we had people moving in and out every 30 days, it would monopolize the elevator. We logistically cannot support having people move in and move out every 30 days. So in that case, that 12-month minimum is likely going to be, hopefully would be deemed to be a reasonable restriction and not unreasonable. But these are going to be determined on a case-by-case basis. And again, consulting with legal counsel for the association is going to be necessary. So what are some restrictions that you might have in your governing documents that that you can keep, that are deemed to be reasonable restrictions? Well, we think that the language that allows an association to enforce a breach against the tenant is probably going to be a reasonable restriction. I do want to caution you about that language. We do not feel it's a substitute for enforcing breaches against the owner of the home, but to add to your enforcing directly against the tenant. That's probably going to be reasonable. How about imposing rental fees, like, rental fees on owners who rent their units to cover the cost of increased administrative expenses? As long as the rental fees can be justified, and you want to look at the Watts versus Oak Shores case on that point, then the rental fee, imposing a rental fee on the owners who rent to cover increased administrative expenses due to the renting are probably going to be deemed reasonable. How about things as simple as requiring the owner of the unit to provide the tenant contact information, maybe a copy of the lease with the financial information redacted? We think those are reasonable. It's reasonable for the association to want to have the tenant contact information in case it needs to contact the tenant for any reason, and also to have a copy of the lease to confirm perhaps that the lease term is in accordance with other requirements under the governing documents. And then the other reasonable restriction is assignment of rents. That's where the association has the ability to collect rental payments from the tenant if the owner is delinquent in assessments. Again, we feel that that's likely going to be a reasonable restriction because it really doesn't prevent the owner from renting. It's if the owner is renting and getting rental income and not paying their assessments, it seems reasonable for the association to contact the tenant and especially after a court order to get those rents assigned to the association. So that kind of breaks down where we are with what is a prohibition, what is an unreasonable restriction. Alex, let's talk about ADUs and JADUs.
Yes. So like I mentioned at the beginning, one of the big reasons that this bill came into play is because, as we all may remember, on January 1st of this year, AB 670, which became, if I'm not mistaken, Civil Code Section 4751, was adopted, and that essentially allowed association, or I should say it a different way, it prohibited associations from in basically prohibiting ADUs or the construction of JADUs on separate interests. So the idea was that, great, we've allowed the construction of these ADUs and JADUs, but now what if there are rules in place by the association that would prohibit actually renting these properties out due to either rental caps or short rental terms or things of that nature. So this bill came into play in a way to ensure that these ADUs and JADUs can be built up and can be rented out and try to help with this housing crisis. Now, I'll just give a very short summary of what ADUs. I see a comment when Alex is speaking. There's a high-pitched sound in the background that's distracting. I'm not sure if it's coming from my end or from someone else, but I'll hold my mic a little bit closer and hopefully that helps. So I want to give a little summary of what ADUs, accessory dwelling units, are, or what junior accessory dwelling units are. You could think of them as they're in the same family, and they're just different requirements for the two. an ADU is an attached or detached residential dwelling unit, and it has completely independent living facilities. It's got provisions for living, sleeping, eating, cooking, sanitation. All of those things are built in, and they're on the same parcel as the separate interest. The picture that we have here on this slide is a good example of what you typically imagine as an ADU. I was speaking with Laurie in preparing for this presentation, and I mentioned that you can get some very elaborate plans for ADUs. I, in fact, had an association that received a request to construct an ADU, and it was an all glass ADU on all sides except for the restroom area, which was built up with your regular walls. But so you can have very elaborate designs, you can have very simple designs, but ultimately it's the idea that these dwellings, these structures have independent living facilities, and they can basically stand on their own, except for the fact that they are part of the separate interest. They're on that separate interest. Now, a junior accessory dwelling unit is limited to, it cannot be larger than 500 square feet. So that's the first thing to consider. The other idea is that JDUs can have separate sanitation facilities, or they may share them with the main building. Typically, what we see in JDUs are garage conversions, because they will provide for sleeping. They may provide some sort of cooking or other kitchen type equipment, but mainly the shower, the restroom, all those sanitation facilities, those are part of the main structure. So you'll see the fact that these JADUs and ADUs are going to become much more popular in the years to come, and certainly with AB 3182 coming into play, associations will likely see requests from their homeowners for the construction of these buildings. And one other aspect of these ADUs and JADUs, which was revised by AB 3182, is that you still need permitting by the city, by the county, in order to construct them. All that same permitting applies, and as you'll see at the very bottom of this slide, what this amendment here for in AB 31 did, AB 3182, what it did was it provides that if the city fails to approve the permits within 60 days, it is automatically approved. So you see just one more way that the legislature is trying to push these ADUs and JADUs to be built, and be built in a timely fashion. I mentioned earlier there's a provision of 4741 that essentially states that an ADU is not counted as a separate interest. So if you have an ADU on your separate interest and you rent it out to an individual, that will not apply towards the rental cap. So that's an important distinction to make, because typically, you are increasing the amount of people that are residing on the separate interest, and overall you are increasing the amount of usage of the amenities within the association. However, there is no impact on the rental cap. So it certainly makes life a little more difficult for associations when it comes to managing and trying to keep their facilities well maintained. But unfortunately, the push is to increase housing. So here, there is no impact on the rental cap, because the law specifically provides that the ADU or JDU will not apply towards it. So,
and Alex, do you think that that's when the owner is still on the property, whether they're in the main residence or in the ADU themselves, or do you think that's across the board?
So it is, and it's interesting. I was reading through Government Code 65852.2, and it is a doozy. I don't recommend anybody read that unless you really want to put yourself to sleep, because it basically provides that the owner, if the owner does reside on the property, that's when it does not apply to the rental cap. However, there are basically that Government Code section, there's two versions of it. One that is going to be in effect starting January 1, that goes until December 31st of 2025, 2024. And then there's a second version of the same piece of law that goes into effect as of January 1, 2025. And the key difference between those two versions is that from the current date until the end of 2024, local agencies cannot require that the owner reside on the property if the ADU is also being rented. So once we get to January 1 of 2025, then local agencies, and the assumption is that also associations, can require that the owners also occupy the main dwelling or the ADU. It can be one or the other. So
yeah, I am looking also at 4741E that says, for purposes of this section, a separate interest shall not be counted as occupied by a renter if the separate interest for the accessory dwelling unit or JADU is occupied by the owner. So and then subsection D says, for purposes of this section, an accessory dwelling unit or junior accessory dwelling unit shall not be construed as a separate interest. So again, whether the lot would be considered as part of a 25% rental cap if there's an ADU that is, or the main residence where the owner isn't in residence, I think is a question under the law. I don't think the law is that clear. Clearly, if the owner stays on the property and is renting out their ADU, they're not going to be included in the rental cap. But if the owner's not there, I think there's a question as to how the 4741 is worded, as far as whether that does fall under the rental cap or whether it doesn't. And I'm not so sure I would say it doesn't fall under the rental cap. It may.
Yeah, that's fair. That's a good way of summarizing it, in fact. So I appreciate that. Yeah. And I do want to make clear that these ADUs and JDUs are still subject to your other reasonable restrictions and requirements, like Laurie was mentioning in the previous slide. There's no short-term rentals. You can't treat it as an Airbnb. You still have that 30-day minimum term that the association can impose. Tenant registration, basically the association being informed or made aware of the fact that this unit is being rented. Those are still requirements that the association can enforce and can impose. One, because the association needs to know who is residing there in case of an emergency. But two, it also helps that if that rental cap does apply, then the association needs to know whether these properties are being rented or not. So it is important to note that although these ADUs and JADUs are separate in the sense that they can be rented out to third parties, that there is a question on whether they apply to rental caps. Certainly when the owner resides on the property, they do not. But then overall, the rules and restrictions that the association would otherwise be applying still do apply to these ADUs and JADUs. So let's take a quick look at some other implications. Laurie did mention legacy owners, and this is something that we talked about it a little bit earlier, but unfortunately there does not seem to be a great consensus on how legacy owners are going to be dealt with. And again, legacy owners is the newer term for grandfathering. So grandfathering is a term apparently that I guess it has some roots in some ideas that are things that we're not going to want to talk about anymore. But now the idea is that legacy owners are the way that we're going to refer to them. And the idea is that these legacy owners typically, based on the language of 4740 in the past, the new rental caps, new rental restrictions, anything dealing with prohibitions of rentals will not apply to them. Now it's a little bit of a question as to how the new rental caps, or if an association needs to amend their terms, how it will apply to the existing owners, the legacy owners. One way to think of it, it truly does matter as to how the association's documents currently read. If there isn't a rental cap that's currently in place and the association goes ahead and does impose a rental cap, or if there isn't a short-term or a duration requirement for these rentals, that certainly will have a big impact. And I don't want to get too far into the different options here, because it's something that Laurie's going to touch on in the next couple of slides, because it deals a lot with how associations can navigate the next steps, because ultimately this bill is going to be in effect as of January 1 of 2021, but the law does seem to provide at least a grace period with respect to amending documents. So the other item here is occupancy restrictions. I mentioned earlier that with ADUs and JADUs, you're going to be having a lot more people living in associations. There's going to be a big impact on parking. There's going to be a big impact on the facilities. If you have tennis courts or pools or other gyms or common area facilities, those are all going to be used more and more because there just is going to be higher density. There's going to be a higher density of people living in these associations. You know, depending on how you feel about it, AB 3182 does not have an impact on occupancy restrictions. In other words, you can have you know, the same 2+1 formula that was previously kind of the rule of thumb or guideline that associations typically use, that continues to apply. And for those that aren't familiar, the 2+1 formula is essentially that you can have 2 people per every bedroom, and then you add 1. So if you have a 2-bedroom unit, you have the 2 people for each bedroom, which gives you 4, and then +1, so you can have a maximum of 5 people residing in that. Now, I will just throw out a caveat that this is not something that is set in stone, or is not something that has been formally recognized at either the state or the federal level. This is more of a guideline. So I would not recommend that anybody try to impose this, especially on families where there's young children, things like that. This is a situation where, you know, the main idea, or the kind of one of the ways of thinking about this is when you have a lot of people living on one property, if you're renting out to college students or things like that, that's usually where this occupancy restriction comes into play. But ultimately, it's not impacted by AB 3182. Despite the fact that we are going to have more and more high density residential situations. So we're going to have to deal with that somehow, and it's not exactly clear how. Unfortunately, the legislature has just told us this is what we need to do, and now we're stuck dealing with you know, dealing with the parking and other issues that are going to arise as a result. So I know I mentioned, yeah, go ahead.
Oh, sorry, I didn't know if you were transitioning.
Yep. Yeah, I was going to say, so I know earlier I mentioned that, you know, we wanted to talk about what the next steps are, because with, you know, legacy owners are certainly one thing that comes into play, but otherwise, how are associations supposed to deal with this law, and what does it mean for their governing documents, for their rules? What if they have existing rental caps, existing rental duration requirements? What do they do with them? And you know, we have some thoughts, and I know Laurie's definitely going to touch on that, but it's something that it's certainly each association will need to work very closely with council in order to figure out how they should move forward with things, because there is a lot of gray area in this law, and especially given that we have all of 2021 before there's some financial penalties that are imposed. This is going to be a crucial 12-month period for a lot of associations.
Yeah, so we want to look at what should you do. So we've told you what the law says. Okay, what do you need to do? So, you know, pretty much every association, you need to have your governing documents reviewed and analyzed, preferably by legal counsel. I realize that sounds self-serving to say have your legal counsel, as we are attorneys, review and analyze your governing documents to see if you have any provisions that are going to be in violation of the new law. But remember, as under the business judgment rule, the board members are entitled to rely on the advice of their experts. And this is an area where you, not only are you entitled to rely on the advice of your experts, you're actually, it's actually almost mandated that you rely on advice of the experts to shield yourselves from personal liability for the decisions that you make as a director. This is one of those circumstances. You need to have your legal counsel review your governing documents. Most likely it's the CCNRs and the rules. It's possible there could be some rental provisions in bylaws, although very, very unlikely. but you need to have legal counsel review and analyze the governing documents to see, are there any provisions like some of the ones we talked about that could be problematic. The statute 4741, the new law, says that as of January 1, you shall comply. Associations must comply with the prohibition on rental restrictions as set forth in 4741. That's as of January 1. It also says that you have to amend the governing documents by the end of 2021. So by 12/31/2021, you have to amend the governing documents to conform to the requirements of new Civil Code section 4741. So that's really why you do need to have your documents reviewed and analyzed. So what are some of the amendments that you're going to need to do? Or one of the questions that we're getting is, do we actually need to change something before the end of this year, before the end of 2020? Now, the statute, of course, is not going into effect until January 1st, 2021, and the amendments are not required until December 31st of 2021. However, there is some concern. For instance, let's say your association has a rental cap under 25%. We know as of January 1st, 2021, that lower percentage, let's say it's 20%, is not enforceable. So some communities are questioning, if we have a rental cap that's under 25%, do we need to amend the governing documents before the end of 2020 to raise it to 25%, or are we going to lose the ability to enforce a rental cap at all until we amend the documents? And again, the statute doesn't answer that question. There's not a great answer to the question or a clear answer to the question. I will say that I don't feel that that's going to wipe out any rental caps. I think it's just going to mean the effect is that you can't enforce the 20% anymore after January 1st of 2021, but you're going to have to enforce a 25%. But to be conservative, if a community is worried about that, you might want to look into amending before the end of this year. How about a minimum rental term that is longer than 30 days? For instance, you have a 1-year minimum rental term. Everybody has to lease for a minimum of 1 year or 6 months. Do we need to change that before the end of this year so that we don't lose the ability to prohibit short-term rentals? That's really the issue here, is that while there could be reasons why a minimum rental term longer than 30 days is justifiable, certainly a minimum lease period of 6 months or 12 months is also going to prohibit those short-term and transient rentals. So it's going to depend on the language. If you have language in your documents that clearly prohibits short-term and transient rentals, you may not need to amend before the end of this year. However, if the only thing you have in place is that you have a minimum lease term of 1 year, then that is something that you might want to look at and get into place before the end of 2020. So those are some of the questions that we're getting in regards to what you need to do now. So let's talk about amending the governing documents next year in 2021. So how are we going to amend the governing documents? If it's determined that you have a provision or provisions that will violate the new law, how are you going to do these amendments? Well, if you have something in your rules, if you have the rental cap, a 20% rental cap in your rule, then you can do a rule change. We would say that prior notice to the members, the law requires that for most rule changes, the association has to provide notice to the members at least 28 days in advance. However, 4355B5 does say that you don't need to go through that 28-day notice period if you're issuing a document that repeats existing law or the governing documents, or a rule change under B4 that is required by law if the board has no discretion as to the substantive effect of the rule change. So if all the board is going to do is raise that 20% rental cap to 25%, and that's in your rules, then there's a good argument that the board can do it. without the prior 28-day notice. The tougher question comes in to when these provisions, and most often these provisions are in the CCNRs. So how are we going to amend our CCNRs by the end of 2021 to bring them into compliance? Do we need a vote of the membership? Well, some CCNRs, and if you've restated your CCNRs, it's possible that the CCNRs allow the board to make changes to the CCNRs without a vote of the membership to bring them into compliance with law. So if you have that language, again, you need to consult with your legal counsel and get an opinion from them as to whether you can use that provision. But if you do have that provision, then you might be able to amend the CCNRs without a vote of the membership. What if you don't have that language? And what if you've got a rental cap that's 20% or less, or under 25%, or some of the other provisions we've talked about, maybe that mandatory waiting period that legal counsel has deemed to be a prohibition on leasing, or an effective prohibition on leasing. Do we need to go to a vote of the membership? You know, this is a tough question, and unfortunately the new law doesn't give us good answers one way or the other. Let's say you do go out to a vote of the membership, because there really isn't anything in the law or in the governing documents that allows the board to make this change without a vote of the membership. But what if you go to a vote of the membership and they vote it down? You know, now you can't amend your CCNRs by the end of 2021, and you know, what does that mean? Or what if you don't get enough participation, which is often the case in doing CCNR amendments, that you don't get enough participation of the members to effectuate an amendment. So, you know, the law just doesn't give good options here. And we would say consult with legal counsel, see if there is a way that the board could do a CCNR amendment without a vote of the membership. Looking at what's the most important thing here. Certainly the statute that mandates that you amend your governing documents by the end of 2021. Clearly the reason for that is to make sure that everybody can look at the documents and understand what the correct provision is going to be. So maybe there's some wiggle room there. There may also be, could you enact a rule instead of amending the CCNRs that says, for purposes of the CCNRs that say our rental cap is 20%, it's actually 25% in conformance with Civil Code Section 4741. Could you adopt a rule change and not amend the CCNRs? Again, statute doesn't give us guidance on this, but that might help to show that the association is taking steps to amend the governing documents to make them conform. What happens if we don't? What happens if we either can't get our documents amended or we don't? Well, the statute 4741 says that a common interest development that willfully violates this section shall be liable to the applicant or other party for actual damages and shall pay a civil penalty to the applicant or other party in an amount not to exceed $1,000. So those are pretty significant penalties. An owner saying that you prohibited me from leasing my separate interest in violation of the law, and I could have leased it for this amount over this many months, that actual damages could be fairly substantial. So not to mention the $1,000 fine for each infraction. So certainly the message is do what you can to amend the governing documents, because it's hopefully going to negate the argument that the association willfully violated. So if you do a rule change to address something in the CCNRs, and let's say you attempt to get the membership vote to amend that provision in the CCNRs, I think that's a pretty good indication to a court that we didn't willfully violate the statute. We did what we could to amend our governing documents by the end of 2021. But this is definitely an area where associations are going to need to navigate this with their legal counsel. It's going to depend on what language you have in the current CCNRs. It's going to depend and rules. It's going to depend on what changes you want to make. Let's say you have a 20% rental cap and you want to go up to 30%, not the 25%. Is that something the board can do without a vote of the membership? Probably not. Clearly, the board can go up to 25% if you've got that language in your CCNRs that allows the board to amend without a membership vote to be in compliance with the law. But any higher rental cap is discretionary. It's not necessarily because of the law. So definitely a lot of, this is kind of a minefield of legal issues on how you're going to amend the governing documents, what the best way is to do it, whether you need a membership vote, and it needs to be laid out for you by legal counsel. So, so that is the story on amending the governing documents. It's a very murky field, I will say. But hopefully that gives you some ideas and some direction of where to go and what questions you should be asking of your legal counsel. So I think that concludes what we have put together to tell you. Hopefully, I know there's a lot of questions, it looks like. So Dave, Hannah, should we get to any of the questions that maybe we didn't address?
Yes, sure thing. So thank you, Laurie, thank you, Alex. And we're going to move on to the Q&A portion of the webinar today. And the Q&A portion is sponsored by EnviroViews, Hughes Gill Cochran Tinetti, and Levy Erlinger and Company. So we have quite a few questions. It looks like there's 48 in here, 20 and another 26 that have already been answered. So we will try to get to as many as we can. And Laurie and Alex, feel free to pull up that Q&A thing and to try to follow along. If sometimes it's easier to read the question if it's a lengthy question instead of just listening. So towards the top, this attendee says he's a member of a limited equity housing co-op, which is subject to Davis Stirling, like condo associations. They do not own their apartments, but are instead entitled to lease them from the co-op. With the lease tied to our share, their leases and bylaws restrict subletting options, including getting roommates. Will this law supersede those provisions in any way?
Yes, it's highly likely that that this law will essentially supersede what you're describing in this question is one of those prohibitions on leasing, essentially. The way that we're approaching co-ops is that the individuals that are leasing these separate interests from the co-op, that we're treating them as the owner of that separate interest. You know, I understand in co-ops it's a different structure with occupancy agreements and things like that. But for purposes of this law, we're treating those individuals as the owners, and then any subleasing from them is essentially where AB 3182 comes into play. So essentially, yes, there is that. Any prohibition on subletting, which seems to be what this question is describing, would likely be unenforceable after AB 3182. And I would hope that it's not, because I can understand that certain co-ops have particular, you know, they have a lot of particular requirements, and there's usually a lot of impact that the board can have on who is not a part of the association. Unfortunately, there's a big risk on exercising those types of discretionary options here, because AB 3182 seems to make it pretty clear that we want to allow people to rent. And if you're going to prohibit it, or if you're going to unreasonably restrict it in any way, then you may be in violation of the law. And eventually, after once we get to January 1, 2022, that's when there may be the willful violation and the fine of $1,000 or and actual damages.
So I see a question from Richard. It's a good question. It says, our CCNRs that have a statement that in effect says that if there are changes to California law that become applicable, they are deemed to be made into the CCNRs without amending the CCNRs. Does that mean we don't have to amend the CCNRs by the end of 2021? I would say no. I would say I think you do still need to amend the CCNRs, because this is the only statute. I will tell you that, you know, however many years and statutes have been adopted by the legislature and into the Davis Stirling Act that make things in the CCNRs no longer enforceable. Like, I'm sure there's a lot of you out there that still don't allow clotheslines, where your CCNRs say you can't have clotheslines. And we know the law was passed several years ago that says you can't prohibit clotheslines and drying racks in the backyard. We know that those provisions are unenforceable to the extent they conflict with California law. But those in the past, none of those statutes have actually said you have to amend the CCNRs or you have to amend your governing documents to be in compliance with the statute. This is the first time that this has happened. And so I don't think that general language in your governing documents is going to prevent you from having to amend. But again, consult with your attorney on that issue. But I would say you probably need to do a specific amendment to comply with the statute. Yeah, go ahead.
Well, I was just saying one thing I intended to mention this earlier when I was discussing legacy owners, but when we're talking about language that we may find in the CCNRs, one part of, when we're talking about legacy owners, you may have a provision in your CCNRs that specifically, you'll probably use the term grandfather, but it will specifically grandfather in owners, and they will not be subject to amendments or restrictions that are adopted, after those CCNRs are adopted. So if that language is found in your CCNRs, it's that's changing the analysis completely, because then you're going to consider the fact that your own CCNRs are allowing for these legacy owners to be to basically work around or otherwise be exempt from these provisions. So I know we're talking when we look at what language is in the CCNRs, it can make a big difference either if the CCNRs allow for these amendments to be made without a member vote, depending, if they are not discretionary, or if there is grandfathering. Both of those types of provisions can have a big impact on the types of amendments that the association will or will not need.
So Richard asked a question, does this affect PUDs, planned unit developments, or planned developments as they're known under the Davis Stirling Act? Yes. The statute applies to all separate interests. There are 4 types of CIDs in California: your condominium, your planned developments, your apartments, and your stock co-op. So, those they apply to everybody. And in fact, the PUDs is really where the ADU and JADU language comes in, because the ADU statute specifically applies to planned developments. So.
There seems to be a few questions about age restrictions in their senior park. The question is, can we restrict the 25% of rentals to match the age restrictions in the senior park?
So I'm not clear on the connection there. I mean, this statute does not overrule age restrictions in a proper senior housing community. So those age restrictions can be imposed on the rentals as well as the owner occupied homes as well.
Okay, and another one is, if they're 100% owner occupied, does the law change mean that all of us legacy units can rent and the 25% is applicable to only the new owners? That seems to be a lot of kind of questions around the legacy.
Well, and keep in mind too that the law is not saying you have to put in a 25% rental cap. It's not mandating that. It's saying you can have that. It's allowing associations, if they want to try to limit the number of rentals in their community. That's the one exception that to prohibiting leasing that the law is allowing associations to do. So you certainly don't have to put in a 25% rental cap if you don't want to. But if you do, if you have all owner occupied, first of all, I want to know where you are, because that's amazing that you would have an all, unless you're like a 3-unit place, then that's not so amazing. But if you are 100% owner occupied and you do want to put in that 25%, then I do think Civil Code Section 4740 does apply and does at least give the argument to be able to legacy in the current owners. 4740 didn't go away. So.
Okay, and so if they're doing an assessment and they find owners have rented out units without approval in previous rental ban, are those renters grandfathered in?
So the question is if they're doing assessments. I'm sorry, can you repeat it?
Yeah, it says, what if doing an assessment we find, so I'm assuming maybe some sort of check on the units they
Oh, I see,
find
like
they've
not
rented.
assessment in terms of money, but evaluation. I get it.
Right,
Okay.
right. They find that owners have rented out units without approval in the previous rental ban. Are those unapproved renters grandfathered in?
So I'm assuming, again, it sounds like there's parts of the question that maybe aren't, or some facts that we don't have, but assuming
Right.
they have a rental, a rental cap. Let's say they have a 25% rental cap. They've kept track of, they know which 25 homes are being rented, and then somehow they find out that there were additional ones that were not under the legacy provision. Can they enforce? I think that's the question, is can they enforce? Yes, they can. I mean, the law is allowing associations to have a 25% rental cap, no lower than that. And if there were violations before that can be enforced, I don't think the new law changes the ability to enforce those violations.
Okay, thank you, Laurie. See, can the HOA board have rental approvals? Can the board create the rental requirements?
I'm going to let Alex answer that one.
Yeah, I saw that question earlier. Let me find it. Can you repeat it one more time, Hannah?
Yes, can the HOA board have rental approvals? And second part, can the board create the rental requirements?
So as far as approving rentals, I would not recommend having the board approve renters. Now, if it's, if we're asking if it's going to go beyond the 25% cap or whatever limitation that the association has imposed, then the governing documents may have some sort of hardship exception, in which case the board can consider some sort of exemption or waiver of those caps. But if the question is more along the lines of, can we simply, have some sort of screening process in which the board can, or, approve or reject the renter, I would advise against doing that. And the second part of the question, one more time, Hannah, I'm sorry.
Yes, I just scrolled past it.
Can the board create the rental requirements? I think
yes, there we go. Yeah.
Yes. So yeah, and that's essentially, what Laurie was discussing in the last couple of substantive slides is kind of the options that the association would have. Depending on how your documents are currently reading, you may want to go straight for a CCNR amendment, or you may be able to do a rule amendment or a rule adoption in the meantime. And the process for rule adoptions, for anyone that's unfamiliar, is essentially that you provide the membership with at least a 28-day notice period, in which time they can submit comments and comments on that new rule that is to be adopted. And then the board considers those comments and ultimately decides on whether to amend the rule based on the comments and feedback received, or the board can simply move forward with adopting the rule as initially written after considering the comments. So yes, the shorter answer is you can adopt the rental requirements. Obviously, they need to be in compliance with the law specific to this AB 3182. But as Laurie did mention, the 30-day minimum term, there is a little bit of wiggle room on that, depending on if there are some extraordinary circumstances. If you recall, Laurie talked about the elevator example, essentially, where a number of a building basically only has one elevator. So the use of that elevator every 30 days for moving in and out can be quite distracting or otherwise impeding on other people's use of the property.
So here's an interesting question. I like this one from Cynthia. Our HOA will not allow owners to rent for longer than a 12-month period over the lifetime of owning the unit. And the minimum term is 30 days. Please opine on the cap of limiting the owner to renting to no more than 12 months of the lifetime of owning the condo. Yeah, I think that's going to be a problem. Again, your board should consult with legal counsel, but I think that has the effect of prohibiting for months, 13 plus however many months that they happen to, or years that they happen to own that condo. So I do think that's probably going to be a problem under the new law. And then this is a question, I think it may have been asked and maybe we answered it, but I do want to make sure that we are clear, you know, or at least kind of can identify the issue. If the association currently has a rental cap with a legacy clause, does the date of the current legacy get replaced by the date when AB 3182 goes into effect? So let me put it in an example that I think might make more sense. Let's say you have an association now that, let's say, before January 1st, 2012, when 4740 originally came into place, let's say they adopted a amendment to the CCNRs that put in a 20% rental cap, so that anybody who purchased before January 1st, 2012 was legacied, they could continue to rent, but people who purchased after January 1st, 2012, or whenever that amendment was adopted, we're subject to the 20% rental cap. And so now they're going to have to increase that rental cap to 25%. But I think the question is, does that mean that everybody who wasn't legacied in under the old provision, are they now going to be legacied in when the association amends the governing documents to raise that rental cap from 20% to 25%? Well, again, law is not very clear. I think there's a good argument that if you want to keep track of the different legacies and who applies what, or which applies when, I think there's a good argument that because again, 4740 didn't go away. So I think there's a good argument that you might have different levels of legacy if you're amending now to conform to the statute. But again, this is a very tricky question, a lot of moving parts, and the law is not that clear on that point. So you want to consult with legal counsel and get an opinion from legal counsel.
Thank you, Laurie. I see one here from Carolyn. I think you guys actually touched on this in your presentation, but regarding short-term rentals, does a clause in the CCNRs prohibiting short-term rentals for separate interests also apply to a room within the unit or separate interest if the owner is in occupancy?
Right. So yeah, I you know, again, it's going to depend on the CCNRs, but certainly I know we write our CCNRs to say that even if the owner is staying in occupancy and they have roommates, that the roommates still can't short-term rent, that you can't short-term rent. But it could depend on what the documents say.
Mm-hmm. Okay, let's see. There's so many questions.
Here, I have one for you. Is there a possibility that there will be legal challenges to this law that may result in changes and modifications?
You know, David, that's a good question. There's a lot of laws in the Davis-Stirling Act that I thought for sure would be challenged by now, and we would have some good appellate cases that would give us some direction, like maybe the solar, you know, panel law, things like that. I haven't seen any cases yet. So if there are going to be legal challenges to this, it could be years. You know, it could be years away before we see the results of any legal challenges that are brought.
And under 3182, is there anything that states that the association can require a background check for any of the renters?
Again, it's going to be, is that a reasonable restriction? I kind of, it goes to Alex. I mean, I think I'll defer to Alex. I think it goes to kind of that concept of, you know, what's the purpose of doing a background check if the association's going to, does the association have the ability to approve or disapprove renters? And that's a very dangerous, slippery slope to go down. Mm-hmm. Alex, do you want to, you know, what are your thoughts?
Yeah, I tend to agree because then the question turns to what happens if you get a background check that has red flags all over it. You know, does the association have the ability to act on a poor background check? And the conservative answer is no. At this point, the association, it would likely be in, you know, some sort of it's either an unreasonable restriction or it's a prohibition, or it's If it doesn't fall within one of those categories, then you run the risk of the owner bringing discrimination claims that this particular person is not allowed to rent because of issues on their background check, which are ultimately, they're going to argue are irrelevant because the association's relationship is with the owner of the property. And although the association should certainly be made aware of any individuals that are renting, that the tenants, lessees, the legal relationship remains between the owner and the association. I saw another question that kind of ties into this, so I'll go ahead and bring that in as well. It's a three-parter, it looks like, but they all deal with the same concept, which is that can associations either acquire a copy of the lease and contact info for the tenants? And the answer to that is yes, because that, without the association having that information, it's going to be difficult to enforce the rental cap, to ensure that the short-term rental requirements, if any, are being adhered to. So yes, the answer to that part. Next question was does the association have the right to evict tenants if they break rules in the place of the owner who won't evict? I've dealt with this issue, and I would love to say yes, because I think it would make associations' lives and boards' lives a little bit easier, but it's a very, very difficult thing to do. Like I said, the relationship is with the association and the owner. And if the tenant is causing issues, all of the pressure should be applied to the owner unless that owner is unresponsive, which does happen. I don't want to say that there is a right to evict the tenants, but I think there are some options if you go through the court and seek some sort of injunctive relief with respect to the issues. It is a possibility. The last question was the right to collect rent directly from tenants if the owner defaults on penalties. And that goes back to that assignment of rents topic that Laurie discussed, which is, in short, yes, that you can include that as long as it is something that the association has objectively, it's an objective requirement that the association has adopted either into their rental rules or into their CCNRs. Yes, that is something that we feel is reasonable and within the scope of the scope and authority of the association.
Here's a couple quick questions. I like this one. We have 10 units in our HOA. Do we have to make the rental cap 30%, where it would be 3 units to rent instead of 2, or 25% would be 2.5? Yeah, you can't have 2.5 units, obviously, renting. So yes, we would say in that circumstance, you have to round up, because 2, if you say 2, that's 20%, it's going to be under the 25%. There were some questions too about what does the 25% rental cap mean? So just to reiterate that, it means that no more than 25% of the separate interests can be rented at the same time. So in effect, 75% of the total number of separate interests cannot be rented once you hit that 25% cap. So just to reiterate that point.
I also saw another question about what a rental fee is. And I know we touched on this briefly, but just to clarify, essentially a rental fee is something that an association can impose on an owner that does wish to rent either their ADU or their entire property, if that rental fee is associated with the administrative time and other expenses that are directly related to the rental of that unit. I know Laurie mentioned I believe it's the Watts v. Oak Shores case. That talks about, they in that case, actually, they had an economist do an entire breakdown of the increase in expenses that result because of renters. And in that situation, it was short-term rentals and it was a weekend rental issue. But ultimately, that same line of logic does apply, that if you can associate additional administrative costs, additional janitorial or maintenance costs with this rental, then those are fees that you can impose on that owner to try to recoup some of that money that the association will inevitably spend.
Here's another quick question. Can the CCNR include fines for members who rent exceeding the rental cap? So the answer is basically, can we enforce, can we penalize owners who are renting in excess of the rental cap? The answer is yes. I would say you probably don't want to put the specific fine amount in the CCNRs because you want to be able to change that, and maybe that should be in the rules. But yes, you can, there's nothing in this law that says you can't enforce against owners who violate the 25% rental cap.
And what about anyone that does not actually amend their CCNRs but implements provisions of AB 3182?
Well, again, if the CCNRs or rules have language that conflicts, that violates the statute. The statute is mandating that you amend the governing documents. So, in my opinion, would be you need to amend the governing documents that violate the statute.
Yeah, this is one of the rare occasions where the bill specifically states that the association shall amend their documents to conform. It typically doesn't, and some associations do take that line of thinking and say, well, we won't enforce our CCNRs because we know they don't comply with the law, so we'll just stick with what the law says. But this is one situation where it would be risky to take that route.
And so how can a resident find out if their mobile home park is under the Davis-Stirling or under the mobile home residency law? Is there a way for them to find out that information?
If they have, if they have actually purchased, the property and there is a process to do that, then they should know whether they actually own the property or whether they're leasing it from the mobile home park. And in those circumstances, those mobile home park conversions, you're going to see a set of CCNRs. They're either set up as a planned development or as a condo, and you're going to see a set of CCNRs with common area that is going to pull them under the Davis-Stirling Act and make them a common interest development. So there should be some recorded document if that happened. I would expect that to see that.
I saw one question from Gerald. It said, what about CIDs that require cars to be parked in their garages? Does that unreasonably restrict JADUs? Unfortunately, the answer is my opinion on the answer, and Laurie, tell me what your thoughts are as well. But a provision that requires cars to be in garages would not be enforceable because it would be an unreasonable restriction on JADUs. Essentially, the intent of AB 670 and now with AB 3182 is that we want to encourage rentals and we want to increase the number of rentals. So a provision like that requires cars to be parked in garages would likely be an unreasonable restriction. And if challenged, the association would probably be in a difficult situation to win that one.
Yeah, I think if I mean, could you enforce it if they convert their garage to an ADU? Probably no. I mean, you're not going to be able to enforce it because what 4751, that's the ADU law, says is that any provision of a governing document that would prohibit or unreasonably restrict the construction or use of an accessory dwelling unit. So certainly requiring a vehicle to be parked in a garage is going to prohibit converting that garage to an ADU. So I do think that you won't be able to enforce that particular provision as to somebody who's converted their home into an ADU, or their garage, excuse me, into an ADU or JADU.
Okay, so I think we have time for probably one more. And just as I think you could probably answer this pretty quickly, there was a question on, I know you've mentioned it a couple times, but when must they comply, the end of 2020 or the end of 2021?
Well, the law says you have to amend the governing documents by the end of 2021. There are some concerns that if you maybe don't have a prohibition on short-term leasing in your documents now, that you might want to amend, or if you have a 20% rental cap, that you might want to amend that up to 25% before the end of 2020 to avoid an argument that your rental cap goes away after January 1 of 2021. I I think there are good arguments to say the rental cap doesn't go away. You just have to now up it, you know, you enforce a 25% rental cap from 20%. But to be conservative and to avoid any potential argument, you may want to amend your governing documents before the end of 2020 if you've got that rental cap that's under 25%.
Thank you, Laurie. And thank you, Alex, for all for your time. And thank you, Laurie, for your time as well, and all these great answers to these questions. And thank you, everyone that participated today and joined us and asked questions and responded. You know, we greatly appreciate you. And I would like to also thank our program sponsors for this presentation, Access Construction and Grayson Community Management. Thank you. Thank you all. And a big thank you to our Q&A sponsors and our dynamic sponsor as well. Thank you. And so we're just about to wrap up today. And again, big thank you to our speakers. We appreciate your time and expertise. And a number of you that joined us today are not actually members of ECHO, and we encourage you to become a member of ECHO. There's a lot of great benefits that you can take advantage of. If you're interested in becoming a member of ECHO, you can email jprice@echo-ca.org or call the office at the number provided, 408-297-3246. And we thank you all for joining us today and hope you have a wonderful rest of your day.
Thank you. We
Thanks,
appreciate it.
everybody.
Take care now.
Thank you. Bye-bye.